My name's Damien van Brunschot. I'm a lawyer and a mediator. If you're watching this video, it's because you're an injured person known in law as a claimant or a plaintiff, and you are advancing a personal injury claim, and I'm retained as a mediator. So I'm actually retained by the lawyers involved, the lawyers for the plaintiff, you, and the lawyers for the defendants. They might be singular or plural depending on the case. But my role is to facilitate a process. The purpose of this video is to help you better understand what I do, what your role is, and how it's all going to play out so that you can in turn make informed decisions. Now, I should say at the outset, and lawyers are not very good at acknowledging this, that we appreciate that this could be quite stressful. You're going to be in a kind of a formal boardroom environment. You'll be with me as a mediator. Might be quite a few lawyers in the room talking about you and your case, what happened to you and why, and aspects around legal culpability and what financial damages or compensation should follow. So we definitely appreciate that it is stressful and difficult, and hopefully you'll find me here as a helpful ear throughout this process. Let's look first of all at my role. So I'm a lawyer, and often in the past my role has been to provide advice or to advocate a certain position. But I'm not here as an advocate, and I'm not here to give advice. I'm here to facilitate a process. I'm a neutral process facilitator. So the best I can do is nudge or basically reality test certain views, but I don't form a view. And that's important that you appreciate that. I am facilitating a process. And it's also important for you to know that what you say to me in your room with your lawyers is confidential. So if it's not on the record, so to speak, information that's well known to the parties, if you tell me something, well then I can't and won't disclose it to the other side unless I get your direct permission. So that's one of the key rules you need to know. Another thing you need to be alive to is the fact that the mediation is what they call at law a without prejudice process. That means effectively, and with limited exceptions, that what's said in this conference room between lawyers can't be used later in a court of law. And that's a well-established legal principle, and it works as a principle because it's encouraging lawyers and you to be candid and honest in the assessment of the case, and that's a process that underpins mediation. So it's what they call without prejudice. Let's now talk about the process, because you'll probably not be entirely familiar with it. So what's going to happen, generally speaking, every mediation is slightly different, but to give you the broad picture, is you're going to come in with your legal team. I'm going to be there in a boardroom, and there'll be defendants, singular or plural, and we'll all meet together, and we'll have what they call a joint session. And that is where your legal team start by saying what your case is, what your case is about, why they consider you'll win the case, what your damages are, and everyone responds accordingly. The lawyers respond accordingly. Sometimes you might even be asked questions, or they might be taken on notice. But that's what they call the joint session, where we get everyone together and we talk about the issues at play. And we have different positions, and you might hear things that you don't agree with, and that's very common. And that's why you've got a legal team. You may write them down and we may come back to them. So it's certainly not the end of, if you like, communication, but it sets the important tone, and it means that people from the outset get their perspectives and views across. It could take 30 minutes, it could be 40 minutes, it could be as short as 20 minutes, depending on the facts. So after the joint session, you then go back with your legal team into your room, and then I actually often just do a shuttle and walk offers back and forth, or may speak to your lawyers, may even speak to you, and then offers are conveyed back and forth. And hopefully, if the result can be achieved, we achieved a resolution, what they call a settlement. What you mightn't be familiar with as well, unless you're, say, in the used car business, is in legal negotiations, in personal injury law in particular, a feature of negotiation is what we call incremental bargaining. It's often the case that offers are high and low and can creep up quite slowly. And remember that you're advised by your lawyers where your negotiating position should be, but it's ultimately your choice as well. And there's input that you need to give and instructions you need to give about where you pitch your offers. So just remember that you mightn't be familiar with it, but it's often a process of incremental negotiation and many offers made. Now, don't think if I'm your mediator that I'm neglecting you if I'm spending more time in a defendant's room or they're often the insurer's room. That's because they hold the checkbook. And so often I spend a lot of time with them getting their views and attitudes and seeing what they're going to do. And that's quite appropriate for my role. And sometimes, in fact, there's a mediation within a mediation. By that I mean that a relevant issue, if there's multi-parties, is not only what you as a plaintiff receive by way of compensation, but also who pays what in the defendant camp in terms of relative culpability, the percentage split, what we call at law apportionment type issues. And they're often quite contentious. So there are often a lot of arguments in that space as well that I'm also involved with. And that may mean that there are times where I spend more time with defendants, and that's just part of the role, doing my job, trying to facilitate a process. Finally, I want you to turn your mind to the question of what are realistic expectations. And I totally get that you've got a great legal team and you're well advised. But you need to remember this about personal injury litigation. I'm not downplaying the fact that something terrible may have happened to you that may have been life-changing or may have had a significant impact depending on the facts of the case. But the reality is that personal injury litigation is a blunt instrument. By that I mean that it comes down to money, financial compensation largely. And there's no AI machine that's going to tell you what your case is worth, what discount should be had for risk and what your case is worth. It's a very human system. It very much depends on what a judge thinks of you and your evidence and your medical evidence, what facts are accepted, how the law is applied. And even within various lawyers, there might be quite a variance within a range of views held on those questions. So it's a very human system. So I mention that because there's a range of outcomes, and you're advised on this, on a good day and a bad day, and various factual findings made. So there's a range of outcomes. So your job as a participant in this process is not necessarily to think about what's your best case, but really to achieve a settlement. What I'll ask you to turn your mind to, and what perhaps your legal team may ask you to turn your mind to, is what is a fair figure that you can live with, having regard to that array of possibilities or probabilities on which you're well advised. I hope that that's useful in terms of how you turn your mind to this process. I hope it's useful too in terms of knowing what my role is. Obviously, I'll be talking to you on the day, I'll introduce myself and maybe talk again about some of these key aspects. But hopefully by watching this, you have a good sense of what you're walking into and the role that I play. Thanks for watching.